Okay, so you're going through a contract and there it is, an arbitration clause. Do you just breeze past it? Or could it actually come back to bite you if you ever have a problem with the product or service?
That's a super common question.
Today, we're tackling something pretty crucial for every consumer out there. If you've agreed to arbitration in a contract, does that mean you're completely locked out of going to a consumer court?
We're going deep into that.
What does the Arbitration Act actually say about this? We've gone through judgments from the Supreme Court of India and talked to legal experts to break down this issue. Our aim is to give you the lowdown on your rights as a consumer, plain and simple.
Yeah, because we're really talking about the interplay between two pretty big areas of law. So we've got the Arbitration Act, which is all about making dispute resolution faster and, keeping it out of the traditional courts. And then you have consumer protection laws. These laws are specifically there to protect consumers, especially since they're often dealing with large companies with tons of resources. So how do these two laws work together?
That's exactly what we're going to figure out. And hopefully, by the end of this, you'll have a much clearer picture of where you stand as a consumer.
Yeah, no more feeling lost in the legal jargon.
Yeah. So first things first, let's just break down what an arbitration agreement actually is. I mean, we see them all the time these days in all sorts of contracts.
Yeah,
But essentially, it's saying that if there's a disagreement, we're going to go to arbitration instead of going through the court system.
right,
So,
exactly.
and the Arbitration and Conciliation Act of 1996, that's what gives those agreements weight.
Right,
Yeah.
that's the foundation. So the Arbitration Act sets up a system where if parties have willingly agreed to arbitration, then that's the preferred way to go. It's supposed to be a speedier process, more specialized sometimes, and it's meant to be an alternative to the usual litigation route.
Hmm.
So the starting point is,
Mm.
if you've signed on the dotted line for arbitration, then, well, you're expected to go that route.
Okay, so that's kind of the general idea with arbitration agreements. But then we have the Consumer Protection Act, which I feel like brings a whole different perspective to this. This law, which was updated in 2019, is all about safeguarding consumers.
Yeah.
It's meant to be a shield, especially when everyday folks are dealing with businesses where there can be a huge power difference.
You hit the nail on the head. Consumer protection laws are like that extra layer of protection because, let's face it, consumers often don't have the same bargaining power as huge corporations.
Mm.
So these laws try to make things a bit fair. The main goal is to make sure consumers have a way to get their complaints addressed quickly, affordably, and effectively. It's about making sure they have real access to justice.
So on one hand, we have this idea that arbitration agreements are pretty much binding. But on the other hand, we have this specific law that's designed to give consumers more power. Now, the big question is, what happens when a consumer agreement, the kind we see all the time, has an arbitration clause in it? Which law takes priority? Have the courts actually dealt with this kind of situation?
They absolutely have. And a landmark case that really cleared things up was the Supreme Court's decision in Emaar MGF Land LTDVF Tab Singh back in 2019. This case went right to the heart of the conflict. What the court said was a game changer. Even if there's an arbitration clause in a consumer agreement that a consumer has signed, they can't be forced into arbitration if they decide to go to the Consumer Protection Act for a solution.
That's a pretty big deal. So basically, just because you've signed something that has an arbitration clause doesn't mean you're automatically blocked from going to consumer court if you need to. That's good to know. What was the court's logic in making that decision?
The court was super clear about it. They said the Consumer Protection Act provides a special route for consumers to get relief, and it's beneficial to them. It's a separate piece of legislation, created with consumer protection at its heart. So consumers shouldn't lose out on the chance to use this law just because they happened to sign some agreement earlier that had an arbitration clause tucked away in it. The court really recognized how important and how unique consumer protection law is. The takeaway for you, the listener, is that arbitration clause you saw might not be the final word when it comes to your rights as a consumer.
Yeah, that makes sense. It's like saying, okay, you agreed to a certain way to handle disputes, but consumer law gives you another way, and you get to choose. So it's not just that one case where this came up, right? The Supreme Court looked at this again in the Hemalatha Devi v. Udayasri case in 2024.
That's right. And that Hemalatha Devi judgment really cemented the idea that consumers have the power to choose. The court was crystal clear. It's the consumer who gets to decide after a dispute comes up whether they want to head to consumer court or stick with arbitration. So even those arbitration clauses you might have agreed to, maybe even years ago, Don't take away your right to decide how to deal with a problem when it actually pops up.
So it's like even if you signed a contract ages ago and there was that tiny arbitration clause hidden somewhere in it, if a dispute comes up, you still have the right to say, you know what, I think I'd rather go to consumer court. Why is that choice so important for consumers to have?
It's huge, actually. There are a few key reasons why this choice matters so much for consumers. First off, consumer courts are designed to be much easier to navigate. They're more user-friendly, you could say. And they often have more power than your typical arbitration setup. For instance, they can actually impose penalties on companies that don't follow their orders, something an arbitrator might not always be able to do. And consumer courts can offer specific types of remedies that might not be as readily available through arbitration. The Hemalatha Devi case actually points out that when you read between the lines, consumer disputes aren't automatically something you have to go to arbitration for. It's up to the consumer to choose that path. So think about it. You buy a faulty product. If you go the arbitration route, you might just get the cost of a repair. But a consumer court could potentially say the company also has to compensate you for the hassle you went through, and maybe even penalize the company for using unfair practices. That's a real difference.
Okay, so the power really does lie with the consumer. But let's go back to the Arbitration Act for a second. Section 8 of that act seems pretty clear-cut. It says that if there's a valid arbitration agreement, a court has to refer the parties to arbitration unless it finds that the agreement isn't actually valid. How does that square with everything we've talked about with consumer rights?
That's where it gets really interesting. Section 8 does seem to make it almost mandatory to go to arbitration when there's a prior agreement. But the Supreme Court has been very consistent in saying that this general rule has an exception, and that exception is for things covered under special laws, like, you guessed it, the Consumer Protection Act. These laws are meant to be heard in specific places, public forums that are set up for a specific purpose, like, in this case, protecting consumers. So when we're talking about consumer rights, the choice of where to go, where to have the dispute heard, usually rests with the consumer, even if Section 8 seems to point in a different direction.
So in a way, we have a bit of a legal tug of war here. We've got the Arbitration Act saying, hey, if you agreed to arbitration, you should generally stick to that. And then we have consumer law saying, hold on, consumers have a specific right to choose their battleground. This whole idea that some disputes are non-arbitrable isn't something new, is it?
Not at all. The concept that some types of disagreements just aren't suitable for arbitration, that's been around for a while in legal thinking. Even the Arbitration Act itself, in Section 2.3, says that Part 1 of the Act doesn't override other laws that specifically state that certain disputes can't be arbitrated. It's like making room for other laws, like the Consumer Protection Act, to have their own rules about how disagreements under those laws should be handled.
So you have the Arbitration Act kind of setting a general rule, and then you have consumer law carving out its own space. To really understand the kinds of disputes that are typically considered off limits for arbitration, we should probably look at the Booz Allen and Hamilton Inc. v. SBI Home Finance Limited case.
Absolutely. That case paints a much broader picture of what can and cannot be arbitrated. The main principle from Booz Allen is that pretty much any civil or commercial dispute that a regular court could handle can also be dealt with through arbitration, unless a law specifically says it can't, or if it's just implied that it shouldn't be.
And that case actually gives us some solid examples of these types of disputes that usually fall outside of arbitration, the kinds of things that are normally dealt with in the public court system.
Exactly. They laid it out pretty clearly. Things like criminal offenses, breaking the law, family disputes like divorce, or figuring out child custody, guardianship cases, situations with insolvency or shutting down a company, issues with wills and inheritances, those kinds of things, and also eviction disputes under specific tenant protection laws. The thinking behind leaving these matters out of arbitration is often that these cases involve what are called in rem rights. It's a legal term, but it basically means rights that affect everyone, not just the specific people involved in the dispute. So those kinds of cases are seen as better suited for public courts. Like who owns a piece of land, for example, that's something that affects more than just the buyer and seller.
Okay, so those examples are what we call in rem actions. Where do consumer disputes fit into all of this? Are they usually in rem or in personam?
Most individual consumer disputes, the kind where you have a specific complaint about a product or service, are considered in personam. That means they're between specific people. But the really important thing here is that even though they're usually in personam, the intention behind consumer protection laws is so strong that the consumer gets to choose where they want to go. It kind of trumps the usual preference for arbitration if there's a prior agreement. Your issue with, say, a faulty phone might seem very specific to you. But consumer law recognizes that when this kind of thing happens to enough people, there needs to be strong protection.
Now, the Arbitration Act itself has gone through some changes over the years. The 2015 amendments were a pretty big deal. They were supposed to make arbitration smoother and less bogged down by court involvement. Did those changes have any effect on this whole balancing act between arbitration agreements and consumer rights?
That's a great question. Those amendments, like adding Section 11(6)(a), though technically that section isn't there anymore, but the idea behind it to limit courts getting involved early on and sending people to arbitration, that idea is still relevant. Those changes were definitely meant to streamline arbitration and keep the courts out of it as much as possible. But the core principle that protects a consumer's right to choose where they want to have their dispute heard, especially when we're talking about a law like the Consumer Protection Act, that principle hasn't changed. The courts have been super clear that those amendments didn't take away the consumer's right to choose.
And then we have the MS Citicorp Finance India Limited v. Snehasas Nanda case from 2025. Even in this recent case, the Supreme Court seems to be standing firm on these key ideas.
Oh, absolutely. The Citicorp Finance case is a perfect example. Even though there was supposed to be an arbitration clause in that specific situation, the Supreme Court doubled down on what they had said in the Emaar and Hemalatha Devi cases. They made it crystal clear. It's the consumer who decides whether they want to go to consumer court or do the arbitration thing. So even looking at this newer case, it reinforces the idea that, as a listener, you're not necessarily stuck with that arbitration clause when it comes to your rights as a consumer.
And what's interesting is that in that case, the court actually ended up ruling against the person who was complaining, but not because of the arbitration clause, right?
It's exactly. The final decision in the Citicorp Finance case came down to other legal technicalities, like whether there was a direct contract and whether certain time limits had passed. But even though they ruled against the complainant, they were very firm about that core principle. A consumer can't be forced into arbitration just because a contract says so. When a consumer wants to use a law like the Consumer Protection Act, the court has to specifically consider whether that kind of dispute is even something that can be arbitrated. They actually referenced the Hemalatha Devi ruling to back this up.
So let's wrap this up and make sure our listeners really understand what we've talked about. If you're a consumer and you're dealing with a dispute and somewhere in a contract you sign, there's an arbitration clause, what does all this legal stuff actually mean for you in a practical sense?
The main thing to remember is this. You, as a consumer, generally have the right to take your disputes to consumer court, even if you agreed to arbitration in a contract. That right doesn't disappear just because you signed a piece of paper. Consumer protection laws are there to protect you, and they give you a clear path to seek a solution. You're not trapped by that fine print. Isn't that empowering?
It's also good to know that you don't have to decide right away when you sign the contract. You get to make that choice later on if a dispute actually happens.
Exactly. Whatever you agreed to initially, when a dispute actually comes up, you have the power to choose. You can decide whether you want to go the arbitration route or take it to consumer court. And that little clause in your contract could actually give you a lot of leverage if a dispute arises.
So it's all about knowing your rights, knowing what the Consumer Protection Act says, and understanding how it works with the rules about arbitration. Every consumer should know this stuff.
100%. Being aware of your rights under the Consumer Protection Act, knowing how it relates to arbitration, that's key for any consumer. It helps you make the best decisions when it comes to resolving disputes.
And on that note, here's a final thought for you to chew on. Since you have this choice between arbitration and consumer court, what are the things you, as a consumer, should think about when deciding which path to take? What might make one option better than the other in your particular situation? It's something worth considering as you navigate the world of consumer agreements and your rights within them. Thanks for joining us today on The Deep Dive.